A federal judge in Fort Worth says his ban on the Obama administration's transgender restroom and locker room rule applies to school districts nationwide and not just in Texas. So what does it mean for the ruling? Joining us live now to talk about it is North Texas attorney Byron Henry. He specializes in business litigation and civil appeals. Mr. Henry, good afternoon.
Glad to be with you.
So what compelled this federal judge here in North Texas to clarify that this rule is not just statewide but nationwide?
Well, lawyers from the Justice Department had filed basically a motion asking Judge O'Connor, the federal judge in the case, to clarify his ruling because it wasn't clear, since there are other lawsuits going on in other states and other federal districts in the country, whether or not this ruling applied only to the parties in the states that are in the case, or did it apply against the Department of Justice, the Department of Education, and the federal government generally nationwide. And so that's what prompted the additional hearing and the actual ruling, in which the judge did clarify his ruling that it does apply against the federal government nationwide.
Now, it's been said that the letter that was sent by the Justice Department back in May didn't carry the force of law. So why did a judge have to get involved in the first place?
Well, the problem is a very fine line between what constitutes agency action under the law. And agency action is basically code word for once the agency makes a determination, everyone is bound by it. And what the judge said was, while it was a close call, a letter saying this is the agency's position, final position, and that federal funding could be withheld, could be a signal to those who didn't follow the agency action. If litigation ensued years later over this issue, they could lose their funding, and the agency could point back to this letter and say, well, we warned you with our letter that you could lose funding. So the judge hung his hat on the idea that if this letter is the agency's final determination on the construction of Title VII and this gender issue with respect to bathrooms and other intimate facilities, then if they can rely on that letter, then so can the state suing can rely on that letter as an agency action. And so that's the problem, is that letter basically put all school districts and all government employers on notice that the agency had taken a certain position with respect to the law.
We have 20 seconds left, Mr. Henry. What do you expect to happen next here?
Well, first of all, the federal government has a right to appeal to the Fifth Circuit, the Federal Appeals Court, on this issue, and they'll have to decide whether to do that. But eventually this case will run all the way through the system, and ultimately it's either going to have to be the United States Supreme Court or Congress that determines whether or not the word sex in federal law includes this gender identity issue, or whether or not the law is going to have to be amended and changed at the federal level, and that's ultimately where this is headed.
Outstanding explanation, Mr. Henry. Thanks so much. That's North Texas attorney Byron Henry.